Hi, everybody. Welcome to today's presentation on Introduction to Earnest Money Disputes and some related matters. I'm Babak Shamsi from Beresford Booth, and look forward to presenting to you today and hope you enjoy today's webinar. So earnest money disputes. I think we'll start from the very beginning, which is what is earnest money? Well, it's actually defined in the statute under RCW 6404-220. Earnest money is defined as, quote, money placed with the holder by a prospective buyer of residential real property to show a good faith intention to perform pursuant to an executed purchase and sale agreement. And we're going to primarily talk about residential issues today. But so earnest money, essentially the money put in with, usually it's with an escrow agent, but deposited as part of an offer to pursue, an executed purchase and sale agreement. And once the purchase and sale agreement is signed, the earnest money plays a role in that. So a purchase and sale agreement typically has two possible categories of seller's remedies. One is forfeiture of earnest money, and the other is seller's election of remedies, which allows them to pursue common law and other bases in law and equity for recovery in the event a buyer breaches the purchase and sale agreement. However, most purchase and sale agreements will check the box of forfeiture of earnest money. Typically, that's what buyers and sellers agree upon. So essentially, the earnest money from a buyer's perspective often, signals to a seller just how serious that buyer might be in pursuing the property that they wish to purchase. It's one of the major characteristics, I think, or major metrics by which a seller will determine whether or not an offer is strong. And so it certainly signals an intent to the seller of the seriousness of the buyer's offer, in addition to the overall purchase price, whether there are contingencies, and on and on. And so in that sense, the amount of earnest money and how it's dealt with becomes very important to secure, a winning offer and move forward with the purchase and sale. By the same token, however, there are legal consequences when someone puts down earnest money and the offer is accepted and the parties have entered into a binding purchase and sale agreement. So if under most circumstances, the purchase and sale agreement has the parties agreeing that forfeiture of earnest money is going to be the remedy for the seller in the event of breach, that kind of puts a limit to an extent on what the seller can pursue in terms of damages. But this is where it's very important to kind of look at the statutes that apply and better understand exactly what's going on. Because I think an astute buyer may realize that under RCW 6404-005 sub 1, liquidated damages for earnest money may not exceed 5% of the purchase price. Now, that is a provision that I often get telephone calls about, and something that we have dealt with a number of times. And, most buyers, I would say, and understandably so, because most people who are purchasing properties are not pouring through the earnest money statute, may not realize that this 5% provision exists. Those that do, however, tend to think that that protects them 100%. So, for example, if they put down, earnest money that's 20% of the purchase price, they may think that they can only, the liquidated damages can't exceed 5% of the purchase price in going forward. So to that, I would say not so fast, because RCW 6404-005 sub 3 says that the section does not prohibit or supersede the common law with respect to liquidated damages or earnest money forfeiture provisions in excess of 5% of the purchase price. Well, that seems kind of inconsistent. But courts have kind of interpreted this to essentially state that when the earnest money deposit is greater than 5% of the purchase price, the seller has all the rights and remedies otherwise available at law or in equity as a result of the failure of the purchaser without legal excuse to complete the purchase. So what does that mean? What it means is that if a buyer has put down 10% of the purchase price as the earnest money and breaches, if the seller can prove damages of that 10%, if the seller can show that they have actually suffered that 10% of damages, this statute is very likely not going to protect the buyer from having to pay more than 5% of the purchase price. They may have to hand over the entire earnest money. By the same token, if the buyer has only put down 5%, then that's the liquidated damages. So it's essentially saying that up to 5% is liquidated damages where, the seller doesn't necessarily have to prove actual damage. The seller just needs to prove that the breach happened, it's the buyer's fault, and there really isn't a defense to it, and they can get up to the 5% purchase price. But that doesn't mean that if more earnest money has been put down, the seller can't essentially prove up their claim to get more than 5%. And again, the area of law on this is a bit gray, and there are a bunch of competing considerations and thoughts, which you would, if you found yourself in this situation, you'd want to consult with an attorney, either as a buyer or a seller, to determine how best to navigate the situation. But the point is that it's not as simple as it seems. It's not an absolute cap. And so putting down earnest money, in excess of 5% or whatever amount is, something that a buyer is going to really have to sit and consider when weighing the strength of their offer to the potential legal ramifications if the buyer, for whatever reason, can't perform. And we'll get into that a little bit more, right now, I should say, because the next consideration are what are some of the potential pitfalls in putting down earnest money and going forward with the purchase and sale agreement. One is the quote unquote non-refundable deposit. I have seen a number of purchase and sale agreements and addendums to those, especially with developers who will put down a non-refundable deposit when discussing earnest money. And that just creates a morass of legal gray area and confusion as to what that necessarily means. I've talked to some of the developers who've done that. And they think that, well, what it means is that it's going to go directly to the seller, but it doesn't mean I can't ever get that earnest money back if, the seller breaches. Others think that no, it's essentially saying I'm so confident in this, I'm basically handing over the earnest money and I'm not going to get it back. But it just creates confusion when you think of what's a non-refundable deposit in the context of earnest money. Better to be clearer than that when determining what it is the buyer and seller exactly have in terms of their expectations of what can happen with their earnest money. Another pitfall, contingencies. In the hot market that we had in the Washington State area, and honestly, it's around the country, as we all know, but just, around King and Snohomish County and elsewhere, waiving contingencies was very common and has been very common up until, I'd say, the first half of this year. With the interest rates rising and buyers perhaps having a little bit less competition amongst themselves for limited inventory, it's calmed down a little bit, but I still see and hear many people waiving their contingencies in order to strengthen their offer. They waived contingencies pertaining to financing, waived contingencies pertaining to inspections, and all of these kind of different things, those two being some of the most important. And that's a pitfall, because when a buyer goes into a purchase and sale transaction to purchase real estate and they put down their earnest money, and then they have a financing problem, but they don't have a financing contingency, or they see something in the inspection that causes them to reconsider whether they want to go through with the transaction or something else comes up, and they don't have an inspection contingency, it may be very difficult for them to get out of the contract. And that's a huge pitfall where the buyer may find themselves in a situation where they don't have a legal basis or legal recourse to get out of the contract without forfeiting their earnest money. So on the one hand, waiving contingencies can be very attractive in terms of securing a contract to purchase property, but it comes with potential big risks from a legal standpoint if that purchase and sale goes south. Another consideration, of course, is limiting the earnest money to 5% of the purchase price or less, essentially dovetailing with what I said earlier about the liquidated damages. If a buyer only sets their earnest money deposit at 5% or less, then they basically have a known loss if something goes wrong, and they've elected forfeiture of earnest money as the reward. If it's higher than that, it may be more of a battle. If there is a breach and if the buyer knows they've breached because the seller is going to potentially prove up what their damages are, and that's a double-edged sword too. I mean, the seller's got to consider whether they want to prove up or can prove up their damages, because oftentimes it can be hard to prove damages, which is why the statute exists in terms of liquidated damages. It can be hard to prove actual damages as opposed to a set amount when you're talking about purchase and sale that's got a 30-day closing. What is the damage if that sale falls through? Every case differs, but there are other circumstances, especially with new construction. I've seen it in new construction involving large-scale apartment buildings where people purchase units, and they essentially, the seller has carrying costs over the course of a year or a year and a half, and people pre-purchase the property. The seller could come back and say, no, I've suffered, significant damages, and you put down a 10% earnest money. I'm not limited to 5% of the purchase price because I had all these carrying costs, and you gotta cover me for that. So essentially, there are risks there as well. And then of course another consideration is what happens to the earnest money. Most of the time, it's held by an escrow agent, and we'll talk about that process a little bit later. What happens when an escrow agent is holding the earnest money, but there's a dispute about who should get it back when somebody breaches the contract. Sometimes the earnest money can be deposited or released directly to the seller, which again, the non-refundable deposit language that I mentioned earlier sometimes is meant to mean that, although definitely not the way that I would recommend someone phrase it. Releasing the earnest money directly to the seller can be very attractive to the seller, and I can understand why a buyer would do that from a competition standpoint. But that's also comes with its own legal consequences of, if that happens, the money's in the seller's hands. And so if there's a dispute, if someone breaches, and oftentimes when there's a dispute, the parties don't agree about who's at fault. If the buyer wants to recover the earnest money, they're going to have to go after the seller to get the money. And the money is already in the seller's hands. And there is a real risk that the seller is taking that money, use that money, or it just might be difficult, even if the buyer wins and gets a judgment, to recover that money back, as opposed to what would happen if the earnest money stays with the escrow agent. Again, I'm going to talk about the process of how that money gets dispersed from there. So one thing to consider also, and this is a little bit off topic but important, is the Form 17 disclosure. And the reason why I'm bringing up the Form 17 disclosure is because even though it's a part of the purchase and sale transaction, it is a separate issue from the contractual document itself. So the Form 17 disclosure is essentially a disclosure statement provided by the seller to the buyer pertaining to the property to be purchased in. It's required for commercial real properties, unimproved residential real properties, improved residential real properties, and that's covered by different statutes. There's a number of exceptions that I've listed on the slide here about when a seller doesn't need to provide a Form 17 disclosure: foreclosures and deeds in lieu of foreclosure, certain gifts and transfers between spouses and domestic partners, spouses, and other matters like that, where it's less than an interest in fee simple, or it's a personal representative of an estate that's making the transfer, or a trustee in bankruptcy, and on and on. So important to consider what the exceptions are to having a Form 17 disclosure. And the last one that's listed there as far as an exception is important as well, because a buyer can expressly waive the right to receive a seller disclosure statement. I've seen that done, again, sometimes for competitive purposes. But if the answer to any of the questions in the section entitled environmental would be a yes, the buyer cannot actually waive the receipt of the environmental section of the seller disclosure statement. So in other words, if the environmental section has a question where the answer would be yes, the seller has to provide that, even if the buyer has waived it, even if the buyer doesn't really want it. The statute creates that obligation, and that's an actionable point that can, come to be if the seller fails to provide that statement and should have provided that statement, and the buyer then finds some sort of environmental issue that would have been disclosed that was not disclosed. That can be a real point of contention. Even if the entire intention of the parties was not to provide a disclosure at all, the statute essentially creates this carve-out for environmental purposes, and I think to a large degree it has to do with health hazards. So from there, I'm going to just go really briefly, and again, I know this is a little bit of an aside, but the Form 17 disclosure is in the statute, and I'm going to just share the statute as well, so that you can look at it when I talk and just sort of run through it quickly. And so here is the statute. And so it's, again, each section has its own, there's a commercial version, residential, unimproved residential, approved residential, but a lot of them are very similar. So there's these seller disclosures. There's questions about title and legal. Do you have legal authority to sell the property? Is title to the property subject to any of the following, et cetera, et cetera. And there's issues about structural issues. Has the roof leaked? Have there been any conversions or remodeling, and on and on. And then you get down to the environmental section that I was talking about before. It talks about flooding and standing water, material damage, shorelines of wetlands, hazardous materials, contamination, et cetera, et cetera. So these are the provisions that, most sellers need to provide to buyers, because it's not that common that buyers waive this, but I do see it from time to time. But certainly any seller absolutely needs to pay attention to the environmental section, even if the buyer has waived the right, just to make sure that there's nothing that they would need to answer yes. Because if there is something that they know and they would answer yes, then they would need to share that, notwithstanding the waiver. So going back to the presentation. So just kind of talking about the Form 17 disclosure. So the point of bringing this up is to say that this is an independent cause of action, independent issue from the purchase and sale agreement. So even if you've got earnest money disputes and forfeiture of earnest money, and essentially the scope of the damages at issue, and you're dealing with that process, that doesn't mean that the buyer couldn't have a separate cause of action under the statute pertaining to the Form 17 disclosure, and that there couldn't be additional issues that the seller could face, and that could actually result in rescission of the transaction, essentially, unwinding it, canceling it, and that kind of thing, which is certainly something far beyond just the forfeiture of earnest money issue and all of that. And then, the reasoning for it is actual knowledge of the error, inaccuracy, or omission from the seller. So it's a high bar, have to prove actual knowledge. It's difficult to prove, but nonetheless, it is an important thing to consider. And, oftentimes it's good for sellers to say, quote unquote, I don't know, if the seller does not know the answer. I have seen from time to time people provide disclosures where they say no, but they don't actually know that to be true. And that can create problems. So going back to the earnest money issue. So we've dealt a little bit with the Form 17, but what happens if there's an earnest money dispute? What happens next when the buyer and seller can't agree? Buyer thinks that the seller breached, the seller thinks that the buyer breached, and now there's this forfeiture of earnest money issue. If the parties have left the earnest money with the escrow agent, which is most common, there is actually a process for dealing with what happens to that money and how do the parties pursue it. That is, contained within the same statute, 6404, which is different, of course, from what happens if the buyer just permitted the seller to take the funds, in which case the buyer essentially has to chase the seller down. If it's kept by the escrow agent or another authorized third party, usually the escrow agent, what happens? Well, that agent is called the holder, and if the holder receives a written demand, and this is right here in 6404-220, if a holder receives a written demand from a party to a transaction for all or any part of the earnest money held by the holder in relation to that transaction, the holder, within 15 days of receipt of the written demand, has to notify all the other parties to the transaction of the demand in writing, and comply with the other requirements of the section. Release the earnest money to one or more of the parties, or commence an interpleader action. Now, the notice must advise the other parties that they have 20 days to object to the release of the earnest money, and that the failure to deliver that timely written objection will result in the release of the earnest money. And so there's a time period essentially dictated by statute in which the holder has to give notification to the other party. If one party says, give me the earnest money, then they have to tell the other party, well, you have this time frame to object to this, and the holder has a responsibility to maintain a log or some evidence of mailing the notice so that it's very clear that they've followed the statutory procedure. And essentially, the holder has to disperse the funds to the demanding party unless that written objection is received within the 20-day period. Or if there is an objection, the holder must commence an interpleader action unless the parties provide consistent instructions to disperse the funds. So essentially, unless they agree, okay, this is going to go to the buyer, or this is going to go to the seller, or we're going to split it, whatever it is, if the parties are consistent. Or if the parties otherwise agree to ask the holder to refrain from filing the action. But otherwise, the holder has to commence the interpleader action. And it has to send notice by mail and email to the parties that it has in its records or is provided by the parties. There's no requirement on the holder to go figure out where the parties are, where to send the notice. It's either in their records or it's been provided to them. The statute takes care to not create too much of a burden on the holder here. But the holder has to notify the parties essentially in accordance with the statute. And then the holder can get its reasonable attorney's fees and costs in commencing the interpleader action. And essentially, the funds are then, the earnest money funds, I should say, are then interpled with the court, and they are with the court, and then the parties essentially have to go to court to argue over who has the right to get the funds and all of that. But the positive for the buyer in that circumstance is that the funds are with the court now. They are not in the hands of the seller, and so they are, for what it's worth, safe from being spent and impossible to ever retrieve, which is why keeping them with the escrow agent is perhaps desirable, because the buyer knows that at a minimum, if the buyer and the seller have a dispute about who should get the money, the holder is going to put it with the court and it's not going to vanish. Whereas if the buyer gives it to the seller, you never know. The seller may abscond with the funds, and it may be a much higher battle, or much more of an uphill battle to get that money back. So earnest money disputes, there's definitely a process. It's discussed within the statutes. There are always the practical considerations, that a buyer and the seller both have to consider when determining, what's an attractive offer, how much risk do I want to take, and all of that. And the buyer and seller, from a practical standpoint, are a bit in competition with each other, right? Obviously, the more earnest money, the better for the seller, not as good for the buyer. Waiving contingencies, better for the seller, not as good for the buyer. Releasing the funds to the seller immediately, good for the seller, maybe not so much for the buyer. So there's those competing interests. And so buyers obviously have a certain amount of drive, especially in a hot market, to take aggressive steps to make their offer more desirable. But those come with legal consequences, and the legal consequences in most circumstances may be a much more difficult time to recover the earnest money that the buyer has put down if they've waived contingencies, if they've just already released it to the seller, or if they've taken, other actions that essentially limit their ability to recover, the earnest money. So, if you find yourself in a situation where you need legal advice or need some kind of recommendation, or just someone to talk to about the earnest money process or the dispute, I do think it's a good idea to talk to a lawyer about it, because the statute is pretty detailed in terms of how parties go about recovering their earnest money. And of course, who breaches the contract is going to depend on the terms of the contract, what the contingencies were, what happened, what was the timeline. They can also be very fact intensive. So legal counsel can be appropriate and helpful in those circumstances. So if you have any questions, you're welcome to contact me. My phone number and email is on the screen right now, or anyone at our firm. Of course, you can call us. That's the general number there. We'd be happy to help you. And I hope you found this presentation informative. It's by no means exhaustive, and there's no one-size-fits-all answer to this. But there are certainly details in the statute that kind of help a party to understand, at least at the outset, on a certain level, what their rights and what their responsibilities might be. So, but beyond that, it can get pretty complicated pretty fast. So feel free to contact us if you need anything. And I hope you enjoyed today's presentation. Thank you so much.